morning, everyone. It's Carol Williams from Williams Immigration, and we are back with another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So the first thing I want to talk to you all about is the visa integrity fee, which is one of the fees that came out of the most recent budgeting bill out of Congress. And there's a visa integrity fee. It is $250. It is a fee to be paid by non-immigrant travelers. So whether you're coming over as a visitor, whether you're coming over as a student or on a work visa, there will now be an additional $250 fee. It's the visa integrity fee. That fee is, while it is in the rule, it is currently on on hold until the federal government can figure out the technical piece of collecting the fee on the front end when the visa is issued and then reimbursing the fee when the travel has finished or ended. So several different agencies need to coordinate for this. One, the State Department, who oversees all of the U.S. consulate, needs to coordinate in order to actually take the fee on the front end because the fee is due when the visa is issued. We know that visas are issued at U.S. consulates overseas. USCIS will probably have a role in this because they will need to confirm the proper visa status for somebody, whether if they apply for the application in the US, but then they had to go overseas to get the visa. So they may have a role in this in terms of just confirming. And then CBP will likely have a role because they will be the ones, or they are the ones that track when individuals come in and out of the U.S. They are the ones that you see in the airports and at the port of entries. So they are the ones that are responsible for admitting people in the correct visa status and inputting into the system, the date that they entered and then the date by which they must leave. As we know, that is, you can see that on your I-94 card. So a couple different agencies are going to need to coordinate for this in terms of the technical piece of the puzzle. So we're just waiting for the government to figure out the physical payment aspect of it as well as the reimbursement piece. So I will keep you updated on that, but I wanted to let you know that that fee is a part of that latest rule. The next thing I want to talk to you all about are the permissible activities when you are in the U.S. as a visitor, whether you are a business visitor, a visitor for pleasure, or you're an ESTA. I get a lot of questions about this, and so I thought we would talk about it this morning a little bit. So B2, people are coming in for pleasure. Think of that as you're coming into the U.S. on vacation, you're visiting friends, you're visiting family, you're touring maybe the national parks, maybe you're going on a ski weekend, maybe you're coming to the beach, but you cannot work if you are here on a visitor visa, so you cannot do substantive work. You cannot enroll your kids in school, and your spouse cannot work. So by work, you cannot sit in an office and do the things that you would normally do at home and get paid for it. Like that, it's work. You cannot volunteer. I have a lot of people asking me if they can volunteer. The answer is no. That is seen as work by the Immigration Service. If it is something that somebody else would normally get paid for, you cannot do it while in the U.S. on a visitor visa. If you were here as a business visitor, which is a B1, that's a little different. You can attend business meetings. You can attend training. What you cannot do is be the point person for a conference where everybody asks you what's happening. AV is talking to you, catering is talking to you about what should they be doing. That's work. That is not merely attending a conference. You are leading the conference, you are running the conference. That is considered work. You cannot, again, sit at a desk for 2 hours a day, 6 hours a day, 8 hours a day, and perform the same duties that you would perform at home. That is considered working. Your kids cannot be enrolled in school, and again, your spouse cannot work. I have a lot of business visitors who want to push that envelope. The hard part about this is that there is no list. There's no magical list of activities anywhere. We find out by trial and error. So I always err on the side of being very cautious and very conservative. But there are some things that you're allowed to do as a business visitor, right? It's a quick business trip. It's a quick trip, to attend a conference, attend some training. It is not hang out in the States for months at a time and do substantive work. We cannot do that when you're here on a business visitor visa. And then we have ESTA, which is also a visitor status. ESTA is for individuals who are from countries that are part of our visa waiver program, so they don't need visas. So under ESTA, you can do all the things that you can do under a B1 or a B2 as a visitor, right? But you cannot work. Cannot do substantive work when you're here in ESTA. So you can attend training, you can go to business meetings, you can come on vacation with a family, you can go visit all the national parks, you can go to the beach, you can go visit New York City, you can go visit the Statue of Liberty, right? You can go visit Mount Rushmore, but you cannot work. In addition, your spouse cannot work, nor can your kids be enrolled in school. So I get those questions quite a bit. So I wanted to sort of have that conversation with you all here Monday morning. The next thing I want to talk about is there is a new visa bond pilot program that is being implemented for B1, B2 visa applicants, so our visitors, again, more on visitors. And it is a trial period. That's why the government is calling it a pilot program. It will be a 12-month program. They do pilot programs often. It's sort of their version of testing and measuring and figuring out if something works, right? Or if it doesn't work. Or if it doesn't work, how doesn't it work? And do they tweak it? Do they want to keep it? Do they want to just scrap the whole idea? So the bond program for business visitors and business visitors for pleasure, so B1s and B2s, will be a 12-month program. It will be for individuals at this point only from Malawi and Zambia. The bond amounts can be $5,000, $10,000, or $15,000. The bond is at the consular officer's discretion. If the consular officer determines that a bond is required, then the bond must be paid before the visa is issued. So they haven't told us how this bond will be paid yet. So it's a pilot program, so we don't have all the fine line details. They are using this bond program. They're looking at it. They're looking at instituting it past this pilot program for countries that have high overstay rates. So countries that are high fraud, where a number of individuals get a visitor visa, come to the U.S., and then don't go back home. So that is, I guess, how they chose Malawi and Zambia. I don't know what the overstay rates are, but they have chosen Malawi and Zambia. The visas that are issued to individuals that are required to post this bond will be single entry visas. So you can only enter on that using that visa one time. And you will have a maximum stay in the U.S. of 30 days. So it is a very tightly constrained visa program, in that it's single entry. You're only allowed in for 30 days. And so that will most likely, that 30-day time frame, and it only lasting a year for the pilot program, is a very concentrated time for them to pull the data that they need from this program to see if it works, see if it doesn't work, again, see if they want to tweak it so that they think it will work, or scrap it altogether. So I will keep you updated on that as we get updates from the agencies. The next thing I want to talk to you all about are prevailing wage processing specifically for perm applications, which are used for green card applications, for our preference-based green card applications, our EB2s and our EB3s. If we're doing those via perm, we need a prevailing wage determination from Department of Labor. Those prevailing wages for a while now have been taking a year to get from Department of Labor. Department of Labor has been cruising through their backlog, which is great. We're all very excited about that. And so right now they're taking roughly about 4 to 6 months. So they've gotten that backlog time down considerably on the prevailing wages. So I wanted to put that out there. I personally am very excited to see that. Having a prevailing wage determination that was taking a year put off, it just extended the amount of time that we were taking to get those applications even started and filed. And so 4 to 6 months for a prevailing wage is much better than the 12 months. So I'm hoping they'll get it done a little bit further, maybe 2 months, maybe 1 month. I can dream. The next thing I have to talk to y'all about is TPS. So we've got an update on TPS. There's several countries that have TPS right now, and most of them are in some sort of legal flux in the court system. So the update this morning is for TPS for individuals from Honduras, Nicaragua, and Nepal. So TPS is now, we are looking at the extension through November 18th, 2025. Your TPS is valid, as well as automatic extensions for the employment authorization document, or the EAD, for those individuals who are in TPS status and they are from Honduras, Nicaragua, and Nepal. So this is crucial not only for those individuals, but also for their employers to know that those individuals have EADs that are automatically extended through November 18th, 2025. That said, the process is still winding its way through the court system. So, but as of today, that is what we have in terms of their ND and the EAD extensions. So I will keep you up to date on that as the court sort of does its thing. We have a new or proposed rule, I should say. It's not new. Well, it is new, but it's proposed. It is a proposed rule regarding the diversity visa lottery. So every year, the diversity visa lottery opens. It's a lottery for individuals to try and get their green card applications. And it is for countries that typically don't send a ton of folks to the U.S. It is so that the U.S. can get more people from across the world into the U.S. and give them a chance at coming here with a green card. So the new proposed rule would require an unexpired passport at the time of entering the lottery. That is currently not required in order to enter the diversity visa lottery. So the proposed rule is to have an unexpired, or to submit a copy of the biographic page and the signature page of the passport that is unexpired when you enter the diversity visa lottery. Comments are due on this notice, this proposed rule. Comments are due by September 19th, 2025 of this year. So if you have comments to make, if you think, after you read it, if you think this should be the case, or if you think it should be different, or if you think it should be tweaked, this is a Department of State proposed rule, and they are accepting comments through September 19th, 2025. And the last thing I want to talk to you about this morning is a quick update. As we know, the Department of State runs and controls all of our consulates and embassies overseas outside of the U.S. So currently, as of a couple of days ago, effective August 7th, so just a couple of days ago, the U.S. Embassy in Harare, Zimbabwe, has paused all routine visa services, including non-immigrant applications, so HSLs, O's, P's, student visas, your F's, your M's, your visitor visas, those are all paused, and your green card. So if you're consul processing your green card, that is also on pause if it was slated to go through Harare in Zimbabwe. They're doing very limited processing of the diplomatic visa. So your A's, your G's. So those are still being processed, but in a very limited way. So we will keep you up to date on when that changes, if you already have an appointment and interview scheduled, they will reach out to you with instructions. So that is what I have. So I wanted to make sure that folks that were slated to go into Harare for an interview are getting that information out to them. So that is all I have this Monday morning. Another edition of Beyond the Soundbite. If you all need assistance with your employment-based or family-based immigration matters, feel free to reach out to our office. We are happy to get a consultation set up with you and see how we can help you. Have a great rest of your Monday and a